Well, folks, Todd Halleck here today. Wanted to talk to you a little bit about some estate planning questions that we commonly get. We're going to try to use these videos to answer to the general public some common questions that we receive here in the office from people calling in or people we're meeting with. And thought we'd start with a really common question we get in really almost every meeting, and that is, if I have a trust, do I still need a will? And the answer is, well, it kind of depends on what kind of trust that you're talking about. But if you're talking about the general revocable living trust that most people like to start with as part of their base plan, then the answer is an emphatic yes. In fact, if you don't have that will, it could cause some real problems. And the reason is this: we call that will a pour over will. And what that will does is it says that if something gets left out of your trust, if you think of your trust like a bucket and it holds assets, or assets pour into it when you die, uh, that bucket, if assets aren't in that bucket, if they're sitting outside of that bucket, those assets might be subject to probate. Well, if there's no pour over will, then those assets are going to pass according to the intestate laws of the state where you live, which means whatever state statute provides, that's what will happen with the assets. If instead you have a pour over will, that will say if any of those assets are left outside of the trust and they need to go to probate, then probate court, you need to send them over to our trust so it can pass, those assets can pass according to our wishes as opposed to according to state law. So assuming we're talking about a revocable living trust, the answer to that question, do I also need a will, is an emphatic yes. You definitely should have a pour over will as a companion to any revocable living trust. I hope you find that helpful. Check back here from time to time as we try to respond to more commonly asked estate planning questions.